few years ago, administrative law was a bench player in legal discourse. Only those really jazzed about Chevron deference and separation of powers seem to be keeping up to date on its stats. Today, admin law is unquestionably in the starting lineup when it comes to thinking through how, when, and to what extent AI will transform government services and systems. That's why we're lucky to have a GOAT of the APA, theories of deference, and all things admin law on the podcast. Thanks so much for joining, Cary.
Thanks for having me. It's a pleasure to talk with you today.
Well,
And
as
I should
always,
say, by the way, my law school will think it's funny to have you refer to me as a goat because that's the mascot for the University of Pennsylvania Law School. For anybody who's an alum out there, um,
there we
I
go.
guess I am in that respect. I don't know if in any other respects, but thank you for the kind introduction. Really
Of
appreciate
course,
it.
of course. I would have lost that bet. Is there a story behind the goat?
I have no idea. We have a statue of a goat in the main gathering area in the law school, and I guess there's a legend that if you rub the goat's nose as a first year law student for good luck, you can pass your exams or something to that effect. But
I like it.
it probably symbolized something at some point in time, and it's lost on me. But anyway,
Well, I'm glad to hear
we
all of your
the area.
graduates are
There we
goats.
go. So
Yeah.
yeah, all of our graduates are goats.
The next motto. You're welcome for that. Well, besides mascot discourse, we will follow our kind of tried and true formula for our Scaling Laws Academy series. First, we're going to explore the most relevant and important aspects of the non-delegation doctrine, how that doctrine may limit use of AI in the government context, and what Cary forecasts will occur in this space as AI continues to progress and the Trump administration urges ever greater use of AI by the government. We'll then repeat that analysis, but with a focus on the Administrative Procedures Act, which we will only refer to as the APA going forward, with a focus on its prohibition on arbitrary and capricious agency actions. It's a lot to get through. We could spend just the whole hour, if not 2 hours, just on the non-delegation doctrine. But we're the goats after all, so we have to be ambitious here. So let's dive first into the non-delegation doctrine. Cary, what is this doctrine? Where can we find it in the Constitution? What's it explicitly mean?
Well, let me maybe if I could back up for just a minute before we get to the non-delegation doctrine and just sort of lay some groundwork about thinking about AI and how it relates to delegation. The whole field of administrative law is really about delegation of authority to administrative agencies. The U.S. Constitution has, as anyone really should know, has three branches of government articulated. Article 1 of the Constitution deals with the legislative branch, Article 2 with the executive branch, and Article 3 with the judicial branch. And yet we have these hundreds of executive agencies that range from the Department of Transportation to the Internal Revenue Service, Environmental Protection Agency, Occupational Safety and Health Administration. Where do these fit within the constitutional scheme? Now, there is text in the Constitution, including in the Necessary and Proper Clause in Article 1, that refers to departments, and heads of departments are referred to in Article 2 with respect to appointments and impeachment. There's, contemplated an administrative capacity. But what's interesting is that, many of these agencies are actually making decisions that set policy. That, in fact, if you look across the whole federal government, in any given year, about 3,000 to 4,000 final rules that have the force of law are adopted by government departments and agencies. And one has to think about, well, where does this authority come from? We've got Congress, the president, the court system, but where is this authority for these agencies to make rules? And this is what gives rise to this concern about delegation, because the answer to the question of where they get the authority is that they've been delegated the authority. Congress passes statutes, and those statutes create these agencies and give those agencies authority to take actions. And some of those actions that agencies are given authority to undertake are legislative in nature, the power to create rules and regulations that have the same legal force and effect, really, as laws passed by Congress. One can go to jail for violating a regulation under certain circumstances. So these are very serious powers that federal agencies wield, and while not all of those 3,000 to 4,000 rules are highly consequential, I mean, many of them are what I would call housekeeping matters, establishing the dates for hunting seasons and fishing seasons and the like. Some are, quite consequential, establishing standards for safe air that we can expect to breathe. And so traditionally, the administrative law field is concerned about the legal justification for wielding some of this significant power to set rules. And the non-delegation doctrine is really all about whether agencies should have that legitimate authority to wield legislative power of creating rules, given that in Article 1 it says, that all legislative powers herein granted under the Constitution are to be wielded by the Congress and exercised by the Congress. So if agencies are deploying legislative powers, if that's what they're doing, then it seems to run up against this notion of Article 1 giving legislative powers to Congress and to our separated powers system. So, the non-delegation doctrine, though, having said that that's the general concern and giving the big background, is in some sense largely been a bit of a paper tiger, in the sense that it's only been invoked really in one year in the 1930s to strike down legislation that the court in the Schechter poultry case, also there's been the Panama refining case, and some other cases along the way that have expressed some concern about the delegation of authority to private entities, but this has only been used in a very limited historical period, and ever since we've had hundreds of agencies that have been created that are wielding delegated power without
Right.
much judicial concern.
Right. So here you've already teed up some excellent background principles to kind of keep in mind. First is obviously we have a federal government of limited powers. And that's not only important with respect to the relationship to the states, but also within the federal government itself, each branch is supposed to be playing a specific role. And in this case, Congress, as you noted, has all legislative powers. And so that begs the interesting question of under which circumstances may it delegate that power without raising concerns about the absence of accountability or diminished accountability, for example. And so as you noted as well, the founders from the get-go, as seen by things like the War Department or the Postal Service, acknowledged that there may need to be some other entities that are helping Congress out. And so, what has been that sort of line drawing exercise of trying to get a sense of when Congress has impermissibly delegated certain powers that it alone should be exercising versus when it's okay, perhaps with that sort of effective, efficient government mentality in mind?
Well, like I said, there hasn't been a lot of line drawing because it's only been used, in a couple of cases from the 1930s to strike down legislation is going over the line, and uh, some scholars say that essentially the non-delegation doctrine is a dead letter, but the court has not ever formally, uh, departed from it. It accepts that there might be some limits. Now, I think that it's important in understanding the non-delegation doctrine to look at the full language of the Article 1 provision. It's not just all legislative powers of any kind, it's all legislative powers herein granted. And what's herein granted in the Constitution are these sweeping powers like regulate interstate commerce, which is what was, I think, really the core problem in the Schechter-Poultry case, in which in the 1930s, the Supreme Court struck down the National Industrial Recovery Act and its delegation of authority to the president to adopt industrial codes of fair competition, and I guess that traditionally is understood to have been problematic because the non-delegation doctrine, the line drawing that you mentioned, has been organized around the need for Congress to provide what's called an intelligible principle for the exercise of some legislative power. So traditionally, as long as a statute gave an agency power under some kind of goal or direction or objective that articulated an intelligible principle, then the delegation would be permissible. And what the court in Schechter-Poultry, one might say, did is say that there was no intelligible principle. What is fair competition? It's just too vague. The problem with that, though, is that there have been many other statutes adopted in the years subsequent to the Schechter-Poultry case, cases where the court has not held that the delegation was impermissible, and where the principle or objective is just as loose and broad and unintelligible as fair competition. The authority to regulate in the public interest. That's legislation that the court has said that's sufficient for an intelligible principle. So I think, in my view, what's different about Schechter-Poultry and how you draw the line is that in the Schechter-Poultry case, it was not just this very loosey-goosey, non-intelligible principle, but it was also the sweeping scope of power to do anything related to the entire economy. And that looks a lot like the power herein granted in Article 1 to Congress to regulate interstate commerce, which is similarly unbounded by a principle, really, and covers the whole sweep of the whole economy. Whereas some of these other statutes might say something loosey-goosey, like regulating the public interest, but they're limited in scope to regulating just telecommunications or regulating just some other limited domain of workplace safety or or environmental protection and so forth. So now, when we can talk about what this all means with artificial intelligence, and with artificial intelligence, it these are sophisticated, powerful, one might say autonomous tools, and so it begins to look like there's some kind of delegation going forward to them. How do
Right.
you
And
square
let's
how
just,
do you
yeah.
square that with this sort of history some kind of limit on delegating authority?
Yeah, and just to pause before we get too into the AI weeds, I think it's important to acknowledge that in addition to perhaps limiting the reach of the non delegation doctrine by virtue of that agency's decision not implicating any of the powers herein granted, we've also seen a bunch of theories of deference evolve over time over why we may feel a little bit more comfortable, even in those cases where it's a little closer to perhaps infringing on the powers that we think are solely supposed to be exercised by Congress. What are some of those theories? Over time, how have courts justified, oh, you know what, we're okay with an agency delegating additional authority to an agency in this case?
Well, I mean, I think the first of all, there's a democratic theory, and that is that Congress, has has blessed these. The agencies only get the authority that Congress has given to them. So sometimes scholars have referred to this as sort of a transmission belt that Congress has sort of tied itself to these agencies, given them some play, but they've blessed this and through legislation signed by the president, and so that's that it's a formal delegation of authority in that respect. I think there's also a recognition that agencies have expertise, and that's an important justification, maybe not the formal legal one, but as a practical, pragmatic rationale that we wouldn't have government. It couldn't really have government function if Congress needed to create all of the rules about and all the specifics about what we should be doing about air pollution. Say,
Or
Congress can
setting
say
the
we want or save or
hunting season
banking
rate.
standards or hunting seasons, right? I mean, like there's any number of decisions that have to be made in running a country, and rules that have to be created, and Congress can certainly set out the in an intelligible way what some of the broader goals are, and then leave it up to the agency. And it's also the case, by the way, that um, agencies are not uh, operating without any oversight either, right? So, uh, like with any kind of delegation, you can have ways of in any kind. Like, I mean, if I delegate authority to my doctor, I can find out more about what they're doing. I can go see a different doctor if I don't like what's happening. Or if I delegate authority to a financial advisor, I can place a limit on certain transactions where I have to co-sign on things. And there have been efforts, and there are still ways and mechanisms for these agencies to be overseen by the president. And there's a whole process of White House review for very significant regulations. There's ways that Congress oversees through hearings, through budgets, ultimately through amending legislation and maybe taking back a delegation. And then there's also ways that these agencies are overseen by the courts as well. There's a whole process of judicial review of agency actions.
Right. So we have various rationales for why we may feel comfortable with the reality of agencies promulgating 3,000 to 4,000 rules every single year, even though I think you'd be hard pressed to find anyone who expected, from a founder's perspective, we'd ever have hundreds of agencies promulgating thousands of rules in any given year. Nonetheless, we've become somewhat comfortable or accustomed to this constitutional design where we just need the EPA to have certain expertise. We need to have the CFPB have certain degrees of effectiveness with respect to hearing from consumers and acting on their behalf. But one interesting thing, and this is where I want to dive into the AI nexus, is
Mm-hmm.
in very few instances will Congress ever say, you, the SEC, are being given this authority to promulgate this sort of rule, but you have to use this tool. You can't use this tool. Don't do any Google searches or only do Google searches. We don't see usually that level of specification. And so now, in a world in which, under the OMB memo M2521, where the Trump administration has said, you agencies, we want you to be using AI. We want you to be tracking how your agency is doing in terms of AI maturation. Are you finding ways to integrate it into more and more processes? Congress may not have anticipated that agencies suddenly were going to be using these new tools in perhaps sensitive use cases or really significant ways. So, how do we start to think through what that means from a non-delegation perspective? Does it change our analysis of whether Congress really intended to delegate to an agency using AI? Is this a new can of worms, or is this just plain toast? No big issue.
Well, I think it's important to distinguish at the outset, by the way, here as we shift into AI. First of all, that AI is more than one thing. I mean, I like to say it's not a technology, singular, it's a technologies. So it can mean a lot of things. So we have to really kind of generalize and as we talk about it. The other thing to think about, too, is that when we're talking about government agencies using AI, they can use it in a lot of different ways. And they could certainly use it in ways that violate a whole host of other kinds of laws. If they're using AI as a tool to suppress speech or to discriminate intentionally against people on the basis of race, there's a whole host of legal parameters and limits that come into play with any kind of agency action, and that would be true whether the agency was using AI or whether they were using just their own, their own pen and pencil to create a rule if it was discriminatory or violative of free speech. So, I want to kind of take off the table though those, because I think those are kind of the easy cases. The question is, then what about other uses where it might raise this delegation kind of concern? Here, I want to make one last distinction, and that is between what in AI terms we will usually hear referred to as a human in the loop versus a human out of the loop kind of a structure for an AI tool. Human in the loop means there's some AI tool that's helping inform agency officials' decisions or actions versus an AI tool that's really substituting for human decision making. I think the interesting case from the standpoint of thinking about the non-delegation doctrine is if human officials are actually being replaced by artificial intelligence. I've called this regulating by robot or adjudicating by algorithm, just to think about some catchy alliterative ways of thinking about this separate realm. I should add that there's very few instances right now that where we can identify where agencies have truly taken humans out of the loop. Uh, I have been tracking and have a database of about 3,000 plus uses of artificial intelligence by the federal government. and I'm hard pressed to really find anything that's truly human out of the loop yet. Um, but um, you know, but it's being used a lot. I mean, and you know, it's or if it is being used with humans out of the loop, sometimes it's very for very inconsequential purposes like internal management, triaging, IT helplines and service calls but in ways that really are directly affecting the public, we really haven't seen that yet. But it's just, I think, a matter of time before this could happen.
Right.
Um,
Well, and just
yeah,
to pause there
yeah,
for a second, I think what's fascinating is to focus on these edge cases of when a human is out of the loop. And for the sake of time, I want to drill down on those. But just to
right.
pause for a second, I think it's important for the public to acknowledge, as you have. Number one, we've been using automated processes and algorithmic processes for a very long time. So it's not as though 2023 came along and now the federal government started using algorithmic tools or AI in some capacity. It's been happening. And I also want to flag that for folks who haven't taken admin law, some of the most consequential decisions in your life will be determined by an agency. If we think about the Social Security Administration, for example, determining whether or not you're going to get benefits. And there's a two factors that I want to draw out there. Number one is first the significance of that decision. Obviously, if you're going to get a benefit from the Department of Veterans Affairs or if you're going to be declared disabled, those are big decisions. The second thing I want to flag, though, is that these processes, as they stand, are not efficient, right? You may be waiting months, you may be waiting years, you may be going through tons of appeals, and they may also not be very accurate, right? And yet we're seeing, let's just pick on this disabilities example, we're seeing AI tools of incredible accuracy that are only going to get better, of incredible speed with respect to detecting, let's say, oh, that was indeed a broken arm. You should receive that benefit. So focusing on these edge cases where let's imagine next year or 2 years, we see an agency say, you know what, we're done with judges, agency judges. We're done with having a human in the loop on some of these important questions. What's the non-delegation doctrine have to say in those contexts?
Right. I think you're exactly right. And, you know, by the way, it's there is a lot of people are just sometimes, you know, I perhaps understandably a little bit creeped out, if you will, by thinking about a government by robot. But I've also heard from folks who say, you know what, I I just like a decision made. And increasingly, as you see these tools being used in the private sector, I think the public will become not only more acclimated to their use, but maybe expecting them more in the government sector too. Like, why do I have to wait so long for a human to make this decision when, you know, I could have a dispute resolved at eBay by an automated tool in a very short period of time? So,
Yeah, and that's just
yeah,
such an important observation because we're already seeing now in the medical context, like I was just discussing, possibilities of it being medical malpractice to not have considered an AI tool before you rendered your diagnosis because of their improvement in accuracy and precision. And so,
right.
to your point, you may say it's effectively an ineffective government, the sort of government we got rid of with the Articles of Confederation. If you imagine folks say, no, we're going to operate government as if AI never happened. Well, that's just ludicrous. No one's going to get on board for that.
Right. Yeah. So ultimately, the test, I think, you know, putting the legal issues aside, and we'll get to this because, you know, one of the reasons why I explore these edge cases is to just see, okay, are there some in really um, ultimate barriers to the use of these tools or not? And if there aren't, then, you know, the question comes down to why not use them or when to use them. And that's always a question, I think, of compared to what. If humans have plenty of, you know, AI, let me just say, you know, AI tools have been criticized for being biased, being non-transparent. But humans are biased, and their decision-making processes can be very opaque, and we can have you mentioned disability determinations. There's studies in the Social Security Administration that show a wild variation between how different Social Security administrative law judges can resolve different disability decisions. Some judges saying lots of things are disabilities, and then other judges that are very stingy and don't. And there are studies that raise concerns that some of these disability decisions are racially biased as well by humans. So it's always a question of compared to what, unless, of course, there are some real true legal limitations. And I guess if you want to take it back to the non-delegation doctrine now, I mean, I think that when we take it to that edge limit and we say, well, could we even imagine, authority to make rules by robot or adjudicate disputes by algorithms where humans are out of the loop? Is that compatible with our body or principles of administrative law, like the non-delegation doctrine? I think the answer is it's yes, compatible. And there's again, taking into account that if they're being used in a way that violates some other laws, they can be problematic. But when it comes just simply to the non-delegation doctrine, that doctrine is really concerned about having administrators take on too much power that's unconstrained. Remember that intelligible principle test that's widely associated with the use of it of power by administrative agencies. Well, AI tools are, if anything, generally inoperable unless they have an intelligible principle. They're very. You've got to have some kind of very mathematically well-defined function that defines how they operate and how they work. So
Right. It wouldn't be as if the Social Security Administration just brought in an AI model and said, solve it. Or just that's
right,
it. Just fix it. It'd say fix what? Based off of what data
do the
or
right
what
thing.
reason?
No, no,
Right, right.
you can't really create an AI tool of that just says do the right thing, and you have to specify it. And now, some of these large language models that we're seeing these days are looking a lot like how they operate in a way that's very human-like. But even they are, based upon very complex, but very mathematically well specified algorithms that are, if anything, I mean, they may be unintelligible just from their complexity, but they're not unintelligible in the way that the non-delegation doctrine had traditionally been understood to be concerned, where they're just unspecified and open-ended to a degree that's unacceptable.
Yeah, and it's really interesting to again ground this in the principles underlying the non-delegation doctrine. It's not saying we don't want you to use the best tool for a task. It's saying we don't want you to use that tool for something that would exceed what we expected you to do. So, it for an agency to use the best tools for, or let's just pick the FAA, which everyone's talking about these days. We would want the FAA to use the latest tools for identifying weather patterns to help set what are the right flight patterns, what sort of training do we want pilots to have. But we don't want the FAA to use that weather data to, for example, start to develop or promulgate environmental regulations, right? We would say, no, that's the EPA. But the
Right.
focus isn't on the tool, it's on the application of that tool, which is really interesting to see you draw out here.
Yeah, absolutely, absolutely, and there's actually another permutation of the non-delegation doctrine that might be of interest to students and others. There is something called the private non-delegation doctrine that could be thought of as relevant here, and this is a constraint on delegating governmental authority to private entities. And there was a case called Carter v. Carter Cole, in which the Supreme Court struck down a delegation of authority to a private entity and declared that that's the most, quote, obnoxious form of delegation. Uh, and this becomes perhaps relevant in the AI context, most of all, because a lot of times we may be talking about government agencies using AI. It's not always the case that the government itself has the internal in-house capacity to build these tools and to run them. They contract out to third parties. And so some might say, well, gee, this begins to look a lot like, maybe the AI tool is this private entity. What about the private non-delegation doctrine? Isn't this the most obnoxious form? And there, it's again to your point about principles. If you look at the underlying principles behind Carter v. Carter Cole and the concern about private delegations of private entities, it's because those private entities may have interests that are at odds with the government, and that are may become corrupt, or maybe making decisions that are not consistent with the overall public interest or with the mandate for the agency. With AI tools, there is a concern, we call it misalignment, that those tools might sometimes act in ways that aren't fully aligned with what the programmer and developer is meant them to. But as long as we can solve that, and we have a tool that's well calibrated, well validated, been verified, and used, in a way that carries out its mathematically determined function, then you don't have the same kind of worry that you have with human beings that might be easily corruptible, or or acting in ways that are in their own self-interest to the exclusion. I mean, so these AI tools are their tools, and they'll do what you tell them to do. Ultimately, if they're not doing that, you modify them, or you unplug them, or you do something else. But um, I think again, under the most extreme edge case scenario, and under our current understanding of the non-delegation doctrine, I don't think agencies really need to worry too much about going forward and using AI, whether it's to follow the Trump administration's instructions to do more of it, or just because they can, in some instances, really improve the effectiveness of government. And the public deserves, I think, the most effective government. And if that can be shown to be something that is assisted by, or even carried out by a machine learning algorithmic tool, then I think governments not only should be thinking that they're free to do that under the non-delegation doctrine, but I think as a moral or policy matter, they should feel a responsibility to explore those options.
Very much agreed. I mean, if you were to tell someone again that, hey, the government or this agency has decided that they don't trust computers because the computer was created by X company, so they're only going to do things by pen and pencil, there would be an uproar, and rightfully so, because you expect ineffective government. And I think, not to get too into the philosophical and theoretical weeds, but there's a reason for a whole emerging scholarly thread that's focused on this right to an effective government. And given the amount of the jump in effectiveness that can occur from AI, it's hard to think about not finding it appear in more and more instances. But we could keep going on and on about that
Yeah.
for
Yeah.
many more hours, because I think it's such an important conversation. And so much of it is just going to turn on public legitimacy and comfort with the use of AI in certain contexts. And that's, again, a whole nother conversation. But now turning to
Sure.
this point,
And
yeah,
one other thing, in addition to comfort, I think agencies just have to be careful with it too. I mean, it's
right,
not, you can't be cavalier with these tools. It's
right,
not easy to just pull them off the shelf and say we've got a better process. So
yes.
they do have to be handled responsibly, tested, validated, ongoing monitoring. So there's some maintenance and some real care that needs to be taken. But if agencies can do that and can demonstrate that they're better, yes,
Well, and two,
people will
that
be
just goes
comfortable
back.
with them.
Yeah,
Right.
it goes
Exactly.
back to that notion of expertise to begin with. Of,
Hmm.
yes, we want agencies to have expert staff in environmental policy or aviation or biological weapons or what have you. Well, now we just need to add and the use of AI, and that requires, to your point, ongoing training and awareness. So, with that in mind, though, shifting gears a little bit to the
Sure.
Administrative Procedure Act,
Yeah.
and our concern under the APA that agency actions not be arbitrary and capricious. Here
Sure.
again, because it's admin law, we refuse to use explicit words that would actually be helpful in making determinations and operate at a horrible degree of abstraction. So, what's this mean in context? What's an agency decision, or excuse me, an agency action to begin with? And then, what's your best approximation from all of your expertise around what the heck arbitrary and capricious actually means?
Well, agency actions are actually defined in the Administrative Procedure Act to fall into two categories. One type of agency action is what we've talked about a lot, the the rules, and that's where this non-delegation question arises, because that looks a lot like legislative authority that maybe Article 1 really should have kept to Congress alone. But the, uh, the the second type of category is orders, and those are uh, decisions like also what we've mentioned, things like whether you qualify for Social Security disability, or whether your company is found to have uh, violated some kind of administrative rule or statutory rule. If it's an adjudication involving some identifiable party, that's an order. And there's lots of those. I mean, anytime we've gone through airport screening, uh, security screening, you've actually been subjected to a federal adjudicatory process. We call it informal adjudication because there wasn't a hearing or anything like that, but there was an individual determination that, oh, you don't have any weapons on you, or too much liquids, you can go through and go board your plane. That's an individualized determination. So we've got rules and we've got orders, and those are the type of actions. And there's, as you can imagine, with all the Social Security disability decisions, all the decisions about how much your Social Security retirement payment should be, how much you owe in taxes or should get as a refund on taxes. There, and who should get through airport security screenings. I mean, there's just millions of orders happening all the time, and then thousands of rules in any given year. So there's a lot of agency actions, and there's a provision in the Administrative Procedure Act, Section 706, that articulates standards for how the courts can review those actions. And those actions have to be constitutional. So, as I said before, they can't violate the First Amendment or your equal protection rights. They have to be consistent with the statute. Okay, so again, you mentioned, a telecommunications or banking regulator can't suddenly start, regulating water pollution, or in other ways act inconsistent with a statute. But there's also a requirement that courts, take a look at the procedures that were followed, and agencies have to follow proper procedures. But putting all of those things aside, there's also this catch-all category that courts can review agency actions, rules, or orders for being potentially arbitrary and capricious, and if they are, that's impermissible. What does arbitrary and capricious mean? Well, yeah, it is fairly open-ended, to be sure, but there's a 1984 decision called Motor Vehicle Manufacturers Association versus State Farm that it gives the canonical test for what agencies have to do to withstand arbitrary and capricious review. And that is a test that calls for the agency to engage in good reasoning, basically. They have to think through the nature of the problem and the goal that they're trying to accomplish, see if they've identified a good range of alternatives, if they've looked at all the evidence carefully, and they've stated, why they've taken the action that they've taken. What's, not permissible is to just toss a coin, or what's not permissible is just to take action because it's going to help the current administration politically. Those are certainly things that maybe Congress can do, even under a rational basis test. The arbitrary and capricious test is a little bit more demanding, and it says it's got to be well reasoned. And some would even call this and do call it a kind of hard look review. That the courts are supposed to take a hard look and make sure that the agency also took a hard look and did its due diligence. Now, what counts as due diligence in an airport screening, or a disability decision, or a decision to create a new banking rule, are going to be a little bit different. But by and large, this is what this arbitrary and capricious test is all about.
Yeah,
And when
to tee up just the State Farm example for folks to get a sort of image in their mind of when we may see this, as admin profs everywhere will shorthand this ANC, arbitrary and capricious standard violated. In State Farm, this is a wild truncation of the facts, but the agency basically could have considered, well, what if we issue a rule about airbags and safety belts, also known as wow, now I can't even remember what we usually refer to them as.
Seat belts, right?
This
was like in the era before people where people wouldn't really buckle up very often, and the federal government was trying to tell the manufacturers, put in place some automatic devices to protect the public, even if they don't buckle up. And you could either, put in airbags, or you could put in these automated seat belts that, whenever you open the door, you sat in, it sort of automatically buckled you up.
And in this case, the agency just said, we're only going to look at an all or nothing proposal. We're not going to explore the more nuance of what if we go with airbags alone, or what if we go with the automatic safety belts alone, but instead just said, oh, it's all or nothing. And so for that reason, the court said, whoa. This is way too easy. Y'all could have just explored some very obvious alternatives. And for that reason, it is arbitrary and capricious, and we're going to make you go through these steps again. Are there any other clear examples of ANC findings that come to mind for you?
Well, one of the common examples during the first Trump administration, and we're also seeing it emerge now in the second Trump administration to some degree, and I think we'll see more of it, is there were instances in which the administration or agencies revoked rules, and by the way, that's an agency action too, right? So putting in place rules is one type of action, but lifting them is also an action. And they lifted them for mainly just to reduce costs on business. And the court said, well, that's that it I understand that, but that's only half of the equation. You also have to take into account whether there are loss of benefits to the public from lifting these rules. And so anytime there's inadequate reasoning, or another instance happened during the first Trump administration where the court decided that the Supreme Court decided that the administration had made a decision about the U.S. Census for political reasons, most likely, but gave other reasons as a pretext. Anytime an agency's failing to give adequate reasons, that's whether it's overlooking key aspects of a problem, not really being forthright with the public, these can be instances of arbitrary and capricious conduct. On the other hand, if the agency, comes forward and explains, here's different alternatives we looked at benefits and we looked at costs and we weighed things, and here's how we came to our decision, that's going to withstand arbitrary and capricious review. The courts say that they're not supposed to be, second guessing the agency. They just want to know why they did it and that there's some good reason for doing it. And that's why there might be, again, at this edge case with AI, a concern, because these are thought to be black box algorithms where it's often hard to know why they actually came up with the outcome that they came up with.
Yeah.
How does that withstand this arbitrary and capricious test if it's a decision being made by a black box AI tool?
We're fortunate to have you to be able to explain your own interpretation of how this may apply, because there is this instance, and I find it whenever I talk to folks about AI, the words black box get mentioned, and then all of a sudden the conversation just kind of comes to a close of, well, I can't understand it. I can't point out exactly how it made that decision, so I don't want it making any sensitive decisions about me. How do you think this could apply under an ANC context?
Right. So listen, I think this is, it's a legitimate concern that people have, right? They want to know that their disability benefits are being decided upon for some rational reason, and in a sound basis. And but yet sometimes, with AI tools, we have issues of what the computer scientists will call explainability problems, where it's just very hard to know exactly why the algorithm reached the result it did. The algorithms are not usually set up to generate, like with traditional statistical analysis, some correlation where you can say, the outcome occurred because a variable X or Y were high or low, and that whenever those are high or low, then you get Z of a certain result. You just kind of get this because the algorithm's processing a lot of data, finding patterns that humans maybe couldn't observe, patterns that might not really be causally related to the outcome, but are correlated to it. And yet they can be very accurate too, right? And I think first of all, again, this is an edge case sort of we're looking at where there wouldn't be humans involved. Second, we're also assuming that the technology is always going to keep the black box totally opaque. And in fact, computer scientists are doing an awful lot to make these algorithms much more understandable. And so that's going on there. But even if you can't truly know exactly why in one individual case, I don't think that's ever been the test for withstanding arbitrary and capricious review. And in fact, even before there were AI models that were in play, agencies, as you mentioned earlier, have been using very complex mathematical models to make decisions, ones that are very hard to resolve. And there were cases that came before the courts. People said, wait a minute, this model is just way too complex, and the agency can't really tell us exactly how how it's working. It's not as simple. It's not able to be, encapsulated in a bumper sticker or some simple formula. And the court said, that's not that's not what the arbitrary and capricious standard requires. What it requires is responsible administration that has looked at the performance of this algorithm, considered it against alternatives, one of which, of course, being humans, right? And if an agency has sufficiently tested the algorithm, validated that it's working, then and that it's certainly doing better than humans, then like this is a gain from the standpoint of non-arbitrary and non-capricious conduct. And again, like with the concern about the private delegation, it's not as if you do all of that and have a responsible AI tool making some decisions that's well validated and well monitored, you have to worry about it becoming corrupt or it's set in its mathematical properties are set, and it can actually improve the rationality as well as the effectiveness of government if it's
Right.
done well.
And it's really interesting to think through a future in which people may say, oh, because you opted for a human to make a decision, that was arbitrary and capricious, which is just wild to think about. But to your point, and something I say frequently, this is the worst AI we'll ever use. It will only get better over time. And for folks who are interested in these questions of explainability and interoperability, questions about how whether an AI can explain itself and how we can draw a line between the input to an AI and the output, listen to a Scaling Laws podcast where I talk with Josh Batson of Anthropic, who's actively studying it at the major labs. You have folks who are spending all their time just trying to figure out how these systems work. And to your point also, Cary, it's fascinating to think about for humans, we can always have extraneous variables pop up into our minds that influence our decisions. Whether your sports team lost the last weekend and all of a sudden you're just upset and you're mad about everything. The AI isn't going to ask, well, did Texas win the national championship last weekend or not? Am I in a bad mood or not about that? Never gets raised. So Cary,
Am
you
I
have
tired or
certainly.
not? Right.
Yeah, am I tired?
Yeah.
None of that. Yeah.
Am
Oh
I
man.
grumpy? Right. Exactly. Yeah.
Gosh.
Yeah. And,
Well,
you're right. And I do think that these tools will get better. And I think we may find that this is on a trajectory similar to what we've seen with DNA testing, if you go back and you actually read some of um, the press coverage and even in some of the legal journals and some of the arguments being played out in the courts back in the late 80s about the use of DNA in criminal proceedings as evidence, people were really saying a lot of the same things that today they say about AI. And yet, because DNA technology has been demonstrated and validated, it's now the gold standard. And so I do think that we are on a trajectory where we could begin to see an insistence of the public on the use of AI tools in the future, and not the resistance that we might see more of today.
Well, Cary, you have certainly lived up to being a goat in both senses, being at Penn and the goat of administrative law. Thank you so much for joining Scaling Laws. We'll have to leave it there.
Thank you so much. Pleasure.